Hey, everybody. We have Eli Albrecht on here today, partner at Albrecht Law. Thanks for joining us.
Hey, thank you so much for having me, Dennis.
It's great to finally get some legal help on here. We have a lot of folks who are interested in buying businesses, and legal is definitely, one of the key points. So wanted to have one of the leaders in the space come on and talk about it some more.
Yeah, thank you. Good M&A lawyers are hard to come by in this space. They mostly are in the big firms on Wall Street. So thanks for having me.
Yeah, and for those that don't know Eli, he started Albrecht Law. Albrecht Law represents M&A transactions for a few different clients across search funds, independent sponsors, smaller private equity firms, and they represent clients in a range of corporate legal matters on the buy side and both sell side. Eli's background, he spent a year with SMB Law Group in the space. Before that, Gibson and Dunn and DLA Piper as well. So someone has come from the deal side down to the smaller search fund and independent sponsor world. And I'm sure it's been a lot of fun on your end.
Yeah, it has been a ton of fun. It's been very unpredictable. Every deal is different and has another wild story, but we're racking up those wild stories every deal.
Well, I think for our guys today and gals and people out there, one main focus for them is the LOI process. A lot of folks are searching really hard right now. They're finding companies. And once they get to the point where they maybe identify a company or speak with an owner, they immediately have legal questions around how do I send out this contract, this LOI to these folks, and what should I be worried about? You hear varying things in the market. So if you could just kind of start with a brief overview of an LOI and how to think about it for our folks, and eventually we'll get into a case study in a few minutes.
Yeah, absolutely. I mean, the LOI, which stands for letter of intent. So this is the first concrete document that you're going to present to a seller and sign with a seller. Sometimes you submit an indication of interest, an IOI, prior to your LOI, but generally, most people will start with an LOI at this level of the market. And so the letter of intent, I look at it as setting the foundation for your deal. So it's going to include all of the really core components, the substantive components of a deal. Things like purchase price. How is the purchase price structured? How much is going to be paid at closing? How much is going to be paid after closing in an earnout or a promissory note or an escrow? And it also will set out, the transition services, what you're going to ask from the seller. And we can do a little bit of a deeper dive into each one of these elements. But the LOI really does three things. It acts to set the foundation for your deal points. Number two, it gives you exclusivity. Exclusivity means the seller needs to take the business off the market, take the asset off the market, so that us as the buyer get exclusive rights to pursue that deal. And that's a critical aspect. And then three, this is your opportunity as the buyer to present who you are. And this is a very important point that most searchers and independent sponsors and even private equity practitioners miss. Your LOI says a lot about who you are. When I look at an LOI, I know whether it was drafted by a lawyer. I know the level of sophistication the buyer has. I usually know the level of equity and debt backing that they have. And I can understand the level of professionalism and the likelihood that person is going to close a deal. And when that seller and the broker look at your LOI, they're asking themselves two things. Do I want to work with this buyer for the next 3-4 months to close this deal? And number two, how likely is this person going to be to close a deal? And so your LOI not only needs to express your deal terms, but it needs to express who you are and why the seller should want to work with you.
Thank you for that overview. And I think you're right on that last point too. It's definitely a great position to really make yourself known to the seller in terms of going forward, who you are, what you represent, and a good place to put a good foot forward in a competitive bidding process if you're working on a competitive asset. So from that standpoint, you mentioned it a little bit, but can you go through the difference between an LOI and an IOI in terms of maybe how much teeth is involved in each document and how to think about using those in different processes?
Absolutely. And so the IOI, an indication of interest, is something that sometimes sellers, brokers will ask for on a deal. And they usually do this if they're running a competitive process where they're trying to funnel down buyers and get to the best price and the best qualified buyer. And so buyers will sometimes be asked to submit an IOI, an indication of interest. The main difference between an IOI and an LOI is really twofold. One, the IOI, the buyer doesn't have access to enough information in an IOI to really develop a concrete offer, mostly around the purchase price. So generally, IOIs contain a purchase price range or even a methodology. And that's, for example, you're looking at a plumbing company and they ask you for an IOI, and you know that they're representing that EBITDA is about 3 million, and you want to offer a 5 times multiple to 6 times multiple. And it depends. And you don't know what kind of add backs are legitimate or not. And you haven't really done a deep dive into the business. You're going to say in your IOI that my offer will be between 5 to 7 times EBITDA as confirmed by quality of earnings provider or as confirmed by due diligence. So first of all, in an IOI, there's generally a range on a purchase price, much less detail. So you're not going to really delineate all the components of the purchase price or all the components of the trend, the closing conditions in a way that you would do in an LOI. And then lastly, IOIs generally do not have exclusivity, or sometimes even confidentiality. Often they're not even signed by, countersigned by a seller. You're usually going to submit an IOI with no exclusivity, which means as a buyer, you really can't dedicate a lot of time and money to diligencing this deal until you have exclusivity, which is why we ask for exclusivity, because we're about to invest a ton of money into hiring a lawyer and hiring an accountant and spending a lot of time doing diligence. We need exclusivity. So the letter of intent on the other side will contain a lot more detail. First of all, it will contain a concrete price, like an actual, hey, this is what we're going to offer. It will contain a breakdown of the price. It will contain, exclusivity for sure. It will contain other binding provisions, like sometimes a fee shifting provision if the seller breaches exclusivity, and a range of other closing conditions, right? Which are those conditions that we're going to need to hit before closing a deal. So the LOI is going to be much, much more detailed. It's going to be based on a little bit more diligence on the buyer side, whereas the IOI is sort of like, hey, I'd be interested in this if I got some more information at this range of price, but I'm not asking you to go exclusive on this until you submit an LOI.
Oh, thank you. And there's a lot of differences there too. And even for those out there thinking about making an approach, sometimes it can be helpful to put in an IOI first just to get the seller's attention, and then move to an LOI if you're not comfortable. Again, there's more teeth in an LOI, and the big thing there is figuring out exclusivity, along with a few other topics that we'll go through in a second during our case study. But before we get there, just a few things I wanted to cover. For the exclusivity period, how do you think about how much time I should put down, given you're in the market a lot and see a lot of deals? What's a standard amount of days that you kind of see out there right now, and where you encourage buyers to think about for the exclusivity period?
It's such a good question. And this is a question I get from buyers almost every day. And every time I draft an LOI, and we often support buyers in drafting LOIs and sellers in reviewing LOIs, and they often say, I really need 60 to 90 days exclusivity. And the truth is, deals will rarely close in less than 60 days. I have closed deals in less than 60 days, but it's highly dependent on the seller providing diligence quickly and the buyer being able to get debt financing and equity financing investors on board very, very quickly. Usually, most deals will close in 60 to 90 days, often longer. So a buyer will come to me and say, hey, I need 60 to 90 days at least for exclusivity. I may need 120 days. Like, I want to put in my LOI 120 days. And that is a bad move. A bad move. When a seller sees exclusivity that's longer than 60, 90 days, they are automatically going to downgrade that LOI in favor of another LOI. And this is what I tell buyers all the time. I've seen deals die for all sorts of reasons. I've seen deals die because sellers have actually died, like physically died. And unfortunately, it happens a couple more times than I would have thought. But deals will die for all sorts of reasons. Quality of earnings will come back. The add backs will have been ridiculous. Working capital is way higher than we thought it was.
Yeah, the family gets involved. There's always something, right?
The son-in-law steps in at the last moment and says that he should be getting 12 times EBITDA. Lots of reasons. Somebody at the country club tells him over at a golf outing that he's getting hosed with his 7 times EBITDA offer. Lots of reasons deals die. Deals almost never die because you run out of exclusivity. Never. when a deal is going right and everybody's proceeding in good faith and we've got a purchase agreement we're working on and we're almost there, if we need more exclusivity, nobody's walking away because of exclusivity. The other thing to keep in mind is that an LOI does not need to get you to closing necessarily. It just needs to get you to a purchase agreement in the event that you're doing a non-simultaneous sign and close, and that's where you sign the purchase agreement first and then you close at a later date when closing conditions are met. So usually you really only need 30 to 45 days of exclusivity to get under purchase agreement. And then from there, the purchase agreement, if drafted by a competent lawyer, the purchase agreement will give you exclusivity indefinitely until closing. So the way I think about exclusivity, don't get hung up on it. Put a date in that's going to elevate your LOI and make sure that you get to the next stage. Don't worry too much about it. Have enough, you need, 60 days or so. But don't ask for too much, or you're gonna your LOI is gonna get tossed to the waste bin.
Yeah, and that's a really important point for folks. Don't put an out of market number on that, because if you're competing against someone who has a standard 60 days or 90 days, you're not going to win that process going forward. They'll pick the other LOI. So it's definitely something to consider. And to your point, if it's a good deal and you're 63 days in, there's a good chance they'll still close the deal anyway for all the work that you've done. And we're going to get to your LOI template here in a second, which I think folks will have a lot of fun going through. Before we get there, just want to ask you quickly, what are 3 positive experiences maybe or good things you see in LOIs, and 3 challenges you see? For those out there, for Albrecht Law, they do encourage you to work with them up front on this kind of stuff. So maybe 3 bad things you see in the market and 3 good things to get people thinking about what to think about before we jump into the template.
That's a great question, Dennis. And so often people will come to me pre-LOI and we'll help them draft the LOI. And we have a small fixed fee for doing that. It's really kind of a throwaway fee, but we do engage with people to draft the LOI, and we find that we will save people millions of dollars in the future for that small fee. I mean, one of the things that I see and don't see in LOIs but I like to see is a delineation between the structure of the deal and how that deal is getting structured. So what I'm talking about is it going to be an asset purchase or is it going to be an equity purchase? And the way to think about this is that if you go, there are lots of reasons. We can have a whole discussion on how to structure your deal, whether it's an asset or equity and what considerations to take into account and whether it should be a merger. We generally don't have mergers at this level of the market because there's no point. But it's mostly asset versus equity, and lots of considerations. Do you have material contracts like government contracts that can't be assigned? So then you have to do equity. Are there licenses that can't be assigned? So then you have to do equity. But generally, it's our preference to do asset, and that's for 2 reasons. One is the asset purchase will basically scoop out all of the assets of that business and move them to a brand new entity that's a nice, fresh entity. It hasn't been around since 1951. We don't have any legacy liabilities to worry about, any old tax liabilities or people coming after us to sue us. Now, sales tax does impute, and some environmental issues do come over even in an asset purchase. And so you have to be careful about that. But usually we leave those liabilities behind, any indebtedness. And then the second reason is very tax beneficial to the buyer to structure it as an asset purchase. And I say that because to reinforce my next point, and I'll say it with a story. So I was representing a buyer the other day, and they had submitted an LOI, and they didn't say whether it was going to be an asset or equity purchase. And as we were proceeding to closing, we were doing it as an equity purchase, and we were assuming that it was going to be a deemed asset sale, meaning that we're doing as an equity purchase, but for us, for tax reasons, it's going to be an asset purchase. The seller was underwriting. They were calculating how much money they were going to get after taxes and put in their bank account as if it was going to be an equity or stock sale. The seller gets a much more beneficial tax treatment in a stock sale and an equity sale than they do in an asset sale. The buyer gets a much better tax treatment in an asset sale. So seller realized he's actually going to be getting much less money than he thought he was going to get, and he walked from the deal. And so the deal died because we weren't upfront about our structure in the LOI. So the first point I will make is be very upfront about the structure in the LOI. If you always go if you put in an asset purchase, you can always go to equity. If you put in an equity purchase, you can't go to asset. So always start out with an equity purchase. The second point I'm going to make is that people submit LOIs from their perspective as the buyer. And buyers come to me all the time. They say, hey, this is what I want to offer. This is why I want to offer it. This is the structure I want to offer. And I say to them, what does the seller want? And often they're dumbfounded. And I was like, well, you've had conversations with the seller and the seller's broker. What do they want?
Right.
And like, there's often not a response to that. And the critical
wind
question.
tunnel. Yeah. I said they're in their own little wind tunnel, just looking at their own stuff, and they haven't spoken to the other side.
Exactly. So I tell buyers all the time, find out what the seller wants. I had a deal a few years back at a big law firm and private equity buyer, and it was a very competitive asset, and they were trying to beat out many other buyers, some really big platinum blue chip private equity groups. And my client, I asked them, what does the seller want? What do they like outside of their work? What do they like outside of their company? And I remember him thinking for a second and hanging up the phone. He's like, I got it. And he drafted into his LOI a donation to a foundation that the seller ended up caring a lot about. And they ended up winning the deal. And that wasn't necessarily manipulative as much as it was just like, how do I put forward an offer that the seller is going to care about and want to engage with? So that's the second point I'll make. And the third point is to go back to one of the first things we said is like, reputation in this community matters. Each time you put out an LOI, you're putting out your word travels fast. And, I work with the same people over and over, the same brokers, the same lawyers, the same debt providers, and we get to know people. And if you're just kind of firing out half, baked LOIs in hopes of this shotgun approach on LOIs, reputation's going to precede you on your next LOI. And I always say LOIs are non-binding, mostly non-binding. There are some binding provisions. They're non-binding from a legal perspective, but they're binding from a reputational perspective. They're reputationally binding. So you are bound to that LOI from a reputational perspective. And if you're the kind of person that's just willy-nilly changing LOI terms, whenever you feel like it, word's going to get around and it's going to hurt future acquisitions.
Yeah, especially in the lower middle market space and the search space where it's not a huge world sometimes. So if you burn up too many of those bridges, it can get back to you. To your point, also, it's not legally binding. So you really do have to step away from the deal. You can do that if it's for the right reasons, but there's definitely a way to go about it. I'm sure you see that all the time on your end. So I think now let me see if I can use my fancy technology here, and we'll go through the LOI from Albrecht Law, and there we go. All right.
Wonderful.
So this is a template from your firm, correct, that you generally use?
Yeah, and this is Dennis shared here first. This is a top-notch IP at Albrecht Law. I developed this form over many, many years. We've submitted this LOI on hundreds and hundreds of transactions, closed many of them. So this has been honed and sharpened over many, many years of M&A practice, and happy to share it here.
Well, thank you very much. And I encourage folks, again, go to Albrecht Law as a result of them sharing this. This is very much internal IP here that they're sharing with us today. And wanted to get a good example of their process for folks that are thinking about this. Because again, it seems you hear different varying reviews. Some folks say an LOI is pretty straightforward. Others on the legal side will say these things make all the difference in terms of the work you put in. So, Eli, on this LOI, what kind of key terms would you like me to jump to first to review it if I'm thinking about this document?
Yeah, let's talk first about the first paragraph. This is your opening impression that the seller is going to read. And I've been on the sell side. The other day, I was sitting with a retiring seller selling their company, and we were looking through LOIs. And this was actually in person. Most is not done in person, but I was sitting with him in his living room, and we were flipping through printed out LOIs, and he was reading the first paragraph. And one LOI was from a young couple, husband and wife. They were individuals. They were not private equity, and they had a picture on their LOI. And that is very rare and a little bit unconventional. but they attached a picture to the bottom of their LOI, and they just seemed like really nice people to work with. And, we went through LOIs and there were some higher offers, but my client, the seller, said, hey, I like these folks. I want to work with them. And so we ended up going with their LOI, even though it wasn't the highest offer. So the first paragraph, you got to have some sort of hook, something that makes you likable. And so that's why that suggested language is in there.
Yeah, especially if you're competing against private equity folks, they're going to have more resources, more capital in general. They've probably done more transactions, but the personal side, especially in the lower middle market, super important to really win in a competitive process and make sure that owner recognizes you. So if maybe it's an unconventional way too, you throw a picture in there of yourself if you'd like to, but also make sure you spend time here and really describe why you will be a steward to their legacy and their company.
Yeah, Dennis, that's such a good point, because you always have to remember that you are generally competing against private equity groups or a private equity platform company that's grabbing an add-on in the $2 to $5 million EBITDA space. Set yourself apart, right? You can compete against private equity, even though you don't have the financial backing or the reputation. There are lots and lots of sellers that would prefer to go with an individual buyer, even with the uncertainty of close, than they would a private equity group. So you got to lean into that strength and do it right up front in an LOI. It's a really good point.
Definitely. I think here, we can start to scroll down now to some of the terms that are going to be important. So, what's noted here is you're putting very much upfront, very plainly, exactly what you're offering. So I'll kick it over to Elliot to talk through the aspects on this page here.
Yeah. So section 1, we're talking about the acquisition. This is, as we talked about, this is talking about the structure of your acquisition. Is it going to be an asset purchase or an equity purchase? Now, this is an LOI for an asset purchase. So if it is for an equity purchase, it's going to be a little bit different, and we're going to have a little bit different language in it. And so, you don't want to use an asset purchase LOI for an equity purchase. So this describes in section 1 how you are going to structure the transaction. Section 2, this is your breakdown of purchase price. Now, you want this to be as clear and concise as possible. You don't have to go into that much detail, but you want them to know how much they're getting up front, how much is coming in a promissory note or deferred compensation or earnout, and then whether you're going to have an escrow. I'll direct your attention to C, and 2C outlines a promissory note. Now, this is not a forgivable promissory note, but if we are going to add a level of forgiveness to the promissory note, which is a very powerful tool, one of my favorite things to do, then we'll have to add some language there saying that the note is forgivable. And I'll just touch on what a forgivable note is.
Yeah, great. You have an example there of what you kind of usually do there.
Exactly. So I'll take a step back and say, we encounter some problems in M&A. And for a good M&A practitioner has lots and lots of different tools to address different problems. And, a very good practitioner will have, sharp, directed tools, to responses to the problem. And a good M&A lawyer is the same way. So a promissory note is generally in response to a problem. And the problem is trying to triangulate a good valuation for what the business should be. Now, that could be because there's customer concentration and we're worried about, there's 4 major customers. We're worried about one leaving. So is the EBITDA really the EBITDA? The other is financials that have not been consistent over years. So let's say last year was a breakout year for them. They've hit 3 million in EBITDA. But the prior years were only 2 million in EBITDA or $1.5 million. And suddenly the seller is saying, hey, trust me, pay me a multiple on 3 million EBITDA, even though over the last 2-3 years, the financials were inconsistent. And so we try, but we want to give them a valuation that represents what they tell us. And I can't sit here and say, hey, actually, I know it's not going to hit 3 million EBITDA next year. It might hit 3 million EBITDA, and I'd like to give them the valuation based on that. So what we do is we give them a promissory note, and a promissory note is a portion of the closing proceeds that is not paid at the time of closing, but it's paid through a loan from the seller to the buyer after closing and paid over a certain period of time. Very advantageous from a cap stack perspective. In larger PE, this is sometimes done in a rollover or an earnout. In smaller deals, promissory note is nice to use for various reasons. It's tax beneficial to the seller. If you delay payments or get interest only, it's beneficial for your cash flow after closing. So what we do is we give them this promissory note. Let's say it's a $3 million EBITDA company and the seller wants 5 times EBITDA. So we're offering 15 million, but there's $1 million there that we're not really sure about. So we say, okay, 2 million, we're going to give you in closing 10 million. So 2 million times 5 times multiple, we'll give you in closing consideration. That 5 million, right? The 1 million times 5 times EBITDA, five times, that's a little spongy. That, we're not so sure about that number. So that's going to be a forgivable promissory note. So if after closing, the business achieves 3 million in EBITDA, then sure, we'll give you, that promissory note will flip into an actual payable note over time. But if the business after closing doesn't achieve that 3 million in EBITDA, turns out, actually, we shouldn't have paid 15 million for the business. We shouldn't have valued the business based on 3 million because that wasn't sustainable. So we decrease the purchase price by the amount of EBITDA below what the target was. So just as a rough example, if we're targeting 3 million EBITDA at a 5 times multiple, and let's say the business actually achieves 2 EBITDA a year after closing, or for a couple of years after closing, 500,000 was not achieved. We multiply that by the multiple. So we're at 2.5 million off the purchase price. So then the promissory note is then forgiven by 2.5 million.
Thank you. That was a great overview. And people out there can kind of think of that as a prove it clause, if you will, where there might be, as Eli touched on, some significant run up in EBITDA numbers or inconsistent numbers that the seller's asking for a full price, and you can structure a portion of that and say, well, we're not totally sure on this part, but we'll pay you if you hit these metrics. And I think it's also important for folks. It's always, you usually use EBITDA in this space for a metric in terms of what's out there.
Yeah, generally the real small deals will use SDE, and some of the bigger deals will use some different valuation, but EBITDA is really the most common and popular valuation metric. For forgiveness, the sky's the limit. We could do subscribers, we could do forgiveness based on material customers. We can really craft this in the way that makes sense for us, just like we would an earnout. But generally I like to say, hey, we're retroactively correcting the purchase price down to what it should have been.
Right. And again, it's all part of the negotiation, but another big lever to think about as you're putting these together during your discussions with the sellers. Again, this is an asset purchase LOI that we're going through. So there's, also different considerations on the asset versus stock side. For there, I think we've touched on kind of section 2. Is there anything else you want to touch on here?
Yeah, the only other point that people get hung up on section 2 is working capital and escrow. So for working capital, there are 2 schools of thought. One is, hey, put in there what the working capital will be, what number the working capital will be. Often that's unknown. I like to push this conversation to due diligence. I like to say, hey, we're going to include a level of working capital because we need to include working capital to support the financials, and it's customary to do so on deals that are $1 million EBITDA and above. But we don't know that number now. But our quality of earnings provider, like you had Chris Barrett on here a little while back, and Chris is absolutely wonderful. He's a quality of earnings provider. He's going to go through and say, hey, your working capital target should be 1.5 million. And that's what we're going to put in the purchase agreement. It's my opinion, you'll hear different opinions from M&A lawyers. My opinion is the LOI is too early to put a target in.
Yeah, I think we'll probably get a different opinion on each interview that we do on working capital, but that's generally what I've heard as well from a lot of folks, is something you negotiate in due diligence. It's very hard on the front end. You don't have enough for the books to really make a good decision there sometimes. You can put in a peg, but again, it's probably subject to a ton of change. So it's almost easier to just leave it blank. And with the understanding you'll negotiate that during due diligence. But it's definitely something to bring up early in diligence as you kind of take the next step if you do go under LOI, because I'm sure you've seen a number of deals fall apart because of working capital.
Yeah, a lot of deals, especially in the lower market. Sellers are kind of incredulous sometimes, and they say, "What? I should leave money in the business for you? This is my AR. This is my accounts receivable. I earned it. I should keep it. I should sweep it at closing." And it's sometimes hard to explain to those sellers and sellers brokers that working capital should be left in the business. So I have seen deals fall apart over working capital. It is a negotiable point. Sometimes we need to go out and get a working capital line of credit and give it to the seller. So yeah, it's a deal by deal kind of thing. I think the last point in this section is the escrow. Escrows are very normal in larger PE deals. Escrows serve two purposes. One, if there is a working capital adjustment after closing in favor of the buyer, it usually comes out of the escrow. So let's say after closing 60 to 90 days, we calculate the working capital and we do what's called a true up. And it actually turned out we overpaid for the business, and because the working capital came in under the working capital peg, called an underage. So then the seller owes us money. That can come out of an escrow. The other reason we have an escrow is to support indemnification. So let's say there's something that happens after closing related to a pre-closing misrepresentation. Let's say we get sued for something that happened prior to closing that the seller didn't tell us about. We're going to have to go back to the seller and recoup that loss. Sometimes that comes out of an escrow. Now, in the lower market, escrow is increasingly unpopular. It used to be every deal had a 5 to 10% escrow. Now, especially if you're including a promissory note, which can actually serve those two purposes of working capital adjustment and indemnification, we're often foregoing the escrow almost entirely unless there is a real diligence issue to support. So let's say they took an ERC credit, and now almost every business that comes up now has an ERC issue, because during COVID, there were these ERC and Josh Siegel, our tax partner, our head of transactional tax at Albrecht Law, diligences these issues and structures around them. But during COVID, all these businesses took ERC payouts, and lots of them were not legitimate. And so there's a risk the IRS comes out. There's a risk of enforcement. So if there is an issue like an ERC credit issue, then we can say, hey, we want to set aside $1 million. Or let's say there's a state sales tax issue, also very common on deals that we see where they're not properly paying sales tax, especially after the Wayfair decision. And so we say, hey, we want to set aside $500,000 in case this issue comes up. That is more reasonable than just kind of setting aside an escrow in your LOI. I generally encourage against that unless there's a real issue that we can point to. So that's the last point on that section.
And we'll have Josh on as well next week for the tax side of things, which is also very interesting part of your group. You do handle the law and the tax side, which there's a lot of complications, but there are benefits to having both under one roof.
Massive benefits. When I first started Albrecht Law, the first thing I did, I woke up in the morning and I said, I need a tax guy, because every MA deal, every corporate deal needs a very sophisticated tax M&A guy. And Josh Siegel is an absolute tax genius. I mean, this guy has worked on $1 billion deals and $1 million deals and can structure. There are not a lot of deals that we don't make clients money through tax structuring and uncover issues through tax diligence. Josh is an absolute asset. One of the things that makes us as amazing as we are. Yeah, no,
it's part that folks don't think about. I think they think about the legal side, think of Q&E, which are both, critical points, but the transactional structuring piece, there's a lot of delayed costs and upfront considerations and things to think through. So it definitely can get pretty intricate depending on, what kind of asset you're buying and the deal you're working on.
Yeah.
In that sense. So it's good to have both of you on for folks to kind of learn and get their deals done on their end. I think moving on, we can move down to maybe some of these other sections now that we've got through the top portion here, but starting with number 3 here, and 4, just kind of want to see your thoughts here.
Yeah. So in number 3, we're getting down to more of the legal nitty gritty, which we don't have to spend that much time on. Most of the seller's time is going to be spent looking at that first and second page around the purchase price. The definitive agreement section just tells the seller that, hey, we're going to draft the first draft of the documents. Now, this is very important because as a buyer's lawyer and as a lawyer, I have seen some horrendous documents, especially in the lower market. And you have the seller represented by, his divorce attorney. It's funny, the other day I was on the phone with a seller's broker, and I got back just an awful markup of the purchase agreement, just way off. Like they're arguing about things that are inconsequential and not flagging things that are actually consequential to a seller. And I said to the seller's broker, hey, where'd the seller find this lawyer? And the seller broker said, oh, the seller, this lawyer represented the seller in both of his last divorces and got great settlements. So now he's representing him in his M&A deal. And it's so typical because that is what we see all the time. Is like,
sure, it's painful for you guys. Yeah.
It's so painful. It can be so painful. So we want to at least control that first draft of the documents, so it's at least in the format that's customary and protective. I tell buyers all the time, like, if it was a seller's choice, this would be scrawled on the back of a napkin and you would send the wire. Everything else beyond that is to protect the buyer. The seller doesn't care. As long as the seller gets their money at closing, transfers the assets, they're fine. Everything else in that 20, 30-page purchase agreement is to protect the buyer.
Right. And I think again, it's really important too with these deals. A ton of stuff can come up. There's always stuff, whether it's legal or accounting or raising investor capital or getting the debt financing, doing diligence. So starting with clean documents during your process on the legal side is super important. And that's why you have that clause there, is you don't want to start with the divorce attorney's paperwork to get going. That's going to cause some headaches.
Yeah.
So we can move down to the next couple, starting with number 4 here on additional terms, maybe some things to think about.
Yeah, so the additional terms are important, and these are not just boilerplate terms. These are terms where the buyer needs to ask himself, what are the things that must happen for me to close this deal? Is it a renewal of a contract with a material customer? Is it a lease assignment? Is it the acquisition of a real estate asset? Is it an offer letter with a key employee that needs to be negotiated and signed prior to closing? So these closing conditions are not just like absence of material adverse effect and all that kind of boilerplate legal language, but these are real issues that need to happen for you to close the deal. And if we sign a purchase agreement and all the closing conditions are met, we're going to be compelled to close as the buyer legally. Now, we need to have closing conditions in there that must happen. The ones I usually see are offer letter, lease, third-party assignment, third-party consent, transfer of licenses, confirmation that material customers are staying on. Those are the kind of closing conditions. I will add something, kind of a funny anecdote. I often try to get in this sentence that closing is contingent on satisfaction of due diligence. Now, that is a very broad out for a buyer. So if the buyer signs a purchase agreement and isn't satisfied with due diligence, they can walk from the purchase agreement. Sellers' lawyers, if they have any wits about them, are going to negotiate that out. However, so I used to, in my LOIs, I used to have this, prong number 1 was the satisfaction of due diligence, to the satisfaction of the buyer. And every LOI I sent out, the seller's lawyer would strike it. Now I started to put it in the lead-in language. So it says the closing will be subject to satisfactory conclusion of due diligence of the business and various conditions including. And for some reason now people kind of skip over that lead-in language and go straight to the prongs. And so I've been getting this due diligence closing condition in most of my LOIs, and then that carries over.
That is a slick way to do it. I was going to say that is definitely the first thing I read in terms of that. That gives you a lot of protections as a buyer in the process.
Yeah, it does. It does. The other thing I did is I started putting in my purchase agreements. Everybody puts their definitions up front on the first few pages. And so I started moving my definitions into an exhibit, which has the same legal effect. But most people, when they're finished reading the purchase agreement, are going to spend very little time reading through the exhibit. And so I found that the level of comments I got on my definitions went down like 80%. So,
And this is why you work with the experts at Albrecht Law, just getting you the little wins in these kinds
yeah,
of things. And one thing there too, I think super important you pointed out is the lease. I feel like everyone forgets that. You are not negotiating with the seller on the lease. It is a separate landlord. You have to make sure that that is part of the process. I had a searcher we worked with on a deal for about 6 months, and they were at close, and the landlord came back to them and handed them a bill for $100,000 of tenant improvements on the building, which was, a few questions there of why I came in at that point. But, they just never had the conversation with the landlord, and clearly the landlord, the seller, had some other agreement going on. So, things like that, don't skip over that section. They're very important to, the end of your deal. So make sure you have the right things in there.
Yeah. Dennis, that's such a good point because, landlords are often ignored. And they often have a veto right on your deal because they need to approve of the lease assignment or consent to the lease, because usually there's change of control restriction in the lease. So you need to get that landlord permission, and they could not care less about your time pressure. They could not care less about your investors and lenders who are all on board. And then often the lender has to negotiate a subordination agreement or like a landlord consent, where the landlord is consenting to certain things with the lender, and they have absolute no motivation to move quickly or make any concessions. And usually they're going to get their pound of flesh as well. At that time, they're going to ask for a larger security deposit. Sometimes they're going to ask for personal guarantees from the new buyer.
Yeah.
It can get messy.
They do not
It's
like to
a
be
really
contacted
good
by the
point.
bank. That's
Yeah.
for sure.
Yeah, Dennis, that's a point only known by people who've had horror stories related to this issue.
Yeah, I felt so bad for this guy. He did so much work on it. But you're right. They come at the end for a pound of flesh, as you said.
Yeah.
Speaking of horror shows, the next one's the non-compete. I've heard some real horror stories here. Maybe let's start with why 5 years, and also in practice, if someone starts to contact my customers, what really goes down.
Yeah. So I had a seller 2 years ago. I was representing the buyer, and this was a commercial plumbing company, and the deal closed, and must have been mere months later, the seller and their son opened up a plumbing company in the same area and started competing and started soliciting employees and taking customers. And it was a terrible, terrible scenario. One of the most detrimental things that could happen to you after closing is a seller competing. That is because they know your business better than you know your business. The seller is much better at running your business than you are after closing. That's just the facts. They have the customer contacts, they have the supplier contacts, in many cases, the employees like them better and will come over or initiate the leaving to join a new seller. This is the worst case scenario for a new buyer. When you're trying to get your bearings and now the seller is starting to compete, or seller's family member is competing kind of surreptitiously, or they're competing in an adjacent business because your non-compete wasn't large enough, wasn't broad enough. This is a very, very critical provision, and one actually your lender and sometimes your investors will insist on being broad enough. So, your initial question, Dennis, was very, very astute, because you can have a broad and restrictive non-compete, and your enforcement is going to be challenging. But let's just talk briefly about the non-compete. So there's a lot of talk about non-competes not being enforceable. Actually, there are two types of legal non-competes. Non-competes for employees, which in some states are not enforceable, depending on whether they're reasonable and narrowly tailored. And then there are sale-based non-competes, which the courts look at sale-based non-competes as a different animal. There is a presumption that there is a legitimate business reason for having a sale-based non-compete. And as long as the seller gets substantial consideration at closing, which is generally kind of dependent on the deal, $100,000, $200,000 is usually enough. It's narrowly tailored in terms of geography and scope and serves a legitimate business purpose. So as long as you have those few things, your non-compete is going to be enforceable. Okay, how do you enforce it? After closing, the seller gets their money, you wire it, now they're drinking margaritas in Tahiti, and you know, what are you going to do? How are you're going to attack that seller? So this is where the promissory note or the escrow or any deferred consideration becomes so critical. And this is why I always tell buyers, you cannot pay your full purchase price at closing. You need to hold back something. The seller needs to have some skin in the game after closing in order to prevent them from doing this. Because you can sue them, and you should sue them, but it's going to cost money to do so. So in the purchase agreement, you need to have some mechanics for a breach of covenant, because that's what this is. It's a breach of covenant. In your purchase agreement, you have certain covenants, which are promises to do things or not do things after closing. If you breach a covenant, the indemnification provisions of the purchase agreement kick in, and then whatever resolution you've negotiated in there will be absolutely critical. So if the buyer can decrease the promissory note or go against the escrow or even go against rollover interests, I've seen people be able to decrease rollover interests. If the company's not worth anything, that's not helpful, or decrease in escrow. You need some enforcement mechanism after closing. Otherwise, it's very, very difficult to enforce.
Yeah, I'm sure we could talk about that for a long time, but, you also have to think about your financial position post-close and who you're dealing with, the seller. So to Ellie's point, make sure you do a deal where they still have some skin in the game, and also make sure you're buying a company from someone that isn't, total shark and is going to, turn around in 12 months and cause you a lot of problems, because you're still trying to figure out how to run the business in the first 12 months. Probably resources are maybe a little more strapped because you just put a bunch of money down for this company, and it's not the best time to be dealing with this. There's definitely a lot of considerations there. I could probably do a whole episode on just that. But
yeah. And Dennis, you kind of skipped over it, but I need to draw attention to it because this is such a critical point that will save somebody's life on their deal. And you said, make sure you're not doing a deal with a total shark. And I posted this on X a little while back, that if the primary correlation to you ending up in very bad situations is sellers being dishonest. And if you get a whiff or you get an indication that a seller is being dishonest in one thing, it is conveying that there's a lot of rot in that business, and it will not work out well. And a lot of people jumped on and commented, every small business has some level of dishonesty, and I disagree. If a seller is dishonest, run. Just run. You cannot do business with a shark. It will end up hurting you in the long run.
Yeah,
that's a really good point, Dennis.
Not like a nice shark, like the ones that, really will take a chunk of flesh off you, and, not in a good way where you're in a bad spot. So, that relationship, as Ellie said, try and identify early. And if you get a whiff of something bad, move on to the next one, unfortunately, and try not to spend too much time there. But speaking of that, the next clause here is transition services, which is an important point. A couple other items here, but transition services is something where, it's often talked about with the seller, and a lot of these folks might be trying to retire soon. So there's various ways to structure this, Ellie, but in your case, kind of how do you view the transition services segment here?
Yeah. Like you said, this is a critical aspect of the post-closing plan. What I tell buyers here is you want to structure something where the day after closing, you close on a Friday. On Monday, the seller comes in and starts working as if nothing has changed. So you need to get at least a few weeks, maybe a couple months, to get your bearings, to learn the business. And the seller needs to, he or she may have $10 million, $20 million in their bank account, but they need to come in the next day and work as if nothing has changed, because otherwise the business will fall apart. Sellers always every seller is an absentee seller. Every seller I talk to is semi-retired and absolutely absentee. And then it turns out after closing, the seller is absolutely critical to the business. I don't think this is nefarious. I think sellers don't realize after 30, 40 years of running a business how important they are to the business and how much institutional knowledge they have in their head. And so we really need them to be engaged and involved after closing. Again, just like the non-compete, enforcement mechanics will be critical here. I just closed a deal last month, and my client called me a couple days ago and said, my seller has not showed up one day for their full-time transition services that they committed to for a month. And they got too emotional and they were upset and they just didn't come into work. And so he said to me, hey, what are our enforcement mechanisms in the purchase agreement? And thankfully, we have strong enforcement mechanisms if we want to go that route. But transition services is critically important. Often what I'm seeing in the lower market is that 1 to 2 to 3 months is generally included in the purchase price. So the seller comes in as they were. More than that is either a per diem or a salary. I'll make 2 additional points on this. One is I have been shocked at how emotional sellers are when it comes to transition services. I had a deal a few years back where the seller was walking away with $80 million debt. And during the deal, we're pretty close to closing. This deal was maybe 2 weeks away from closing, and my client presented a consulting agreement to the seller where he was going to pay him $150 an hour for consulting. We got an email the next day saying, thank you for engaging these past few months. Deal's off. You've disrespected me. My time is worth at least $300 an hour. How dare you offer $150 an hour? You think I'm worth that little? Deal's off. And we were shocked because this guy's getting $80 million at closing. What does he care about his
billable hours for, here and there stuff? I agree.
Yeah. So, and the converse of that is that you can use it as a way to sweeten the deal in a way that's not necessarily, of course it has to be underwritten, but if you need to sweeten the deal and make sellers a little more comfortable, especially in those final days before closing, where I call it the seller death spiral, where sellers start freaking out about their transition plans, and you can say, okay, hey, I'm gonna pay you $200,000 this coming year. Just kind of pick up the phone when I need you, right? Or I'm gonna pay you $400 an hour at my discretion if I need you. And sellers are often kind of placated by that. It's a good tool to be able to use to make sellers happy if you really need to get over some sort of working capital negotiation or something like that.
Yeah, it's definitely, again, it's not something to skip over. It's super important. A lot of times you have to have a very personal conversation with that seller. Some folks are looking to sell and retire, hit the beach right away. And other folks, might want to stay around for a year or two. And it really depends, especially on the SBA side. There's limitations there. On the lower middle market side, you're going to want them involved. And to your point, available to call. So make sure you handle that portion correctly. And, one other thing I will add there is make sure you understand exactly how the handoff is going to go. A lot of folks talk about this deal. The deal happens. For whatever reason, the seller always goes on vacation 2 weeks before it closes. And then the deal closes and there's like this weekend where the person comes into the office and no one's told anybody and there's no communication. So make sure as part of that transition agreement, you talk about just how exactly you're going to tell the customers and the employees, et cetera. It's a very big part of it. So I guess on the bottom here, what sections we want to focus on so we don't run too long today, but to kind of finish up.
All the rest we can sort of skip through. Due diligence just sets out that the seller needs to let you kind of dig into the business. Conduct of business is important because it restricts the seller from making any radical changes to the business between signing the LOI and signing the purchase agreement. So, we don't want him going out and hiring a bunch of people or issuing a bunch of bonuses, right? After we're really engaging in this deal. Exclusivity is a big one. We talked about this at the top of the call. Exclusivity gives you the opportunity to dig into the business without worrying about somebody else coming along and offering a better offer and scooping it out from under you. These are the rest of the provisions: confidentiality, public announcements, expenses. These are legally binding provisions. We call these the binding provisions that are actually the binding part of the LOI. So the LOI is mostly non-binding, but partially binding in these kind of critical terms. The only thing I'll draw your attention to in section 12 is I have a fee shifting provision for if sellers breach exclusivity. So if you see in the expenses, if sellers breach their exclusivity and they start talking to other buyers, we can go after them for our costs. Now, I have never seen us go after someone for costs and the seller saying like, oh, okay, cool, here, I'll pay your costs. It's never like that, but it does deter sellers from doing that when they're like, when the seller's broker calls them up and says, hey, we got another offer here, you want to take a look at it? And the seller says, well, are we allowed to? What are the consequences? And then their lawyer says, well, the consequences are that you can pay their expenses. It'll deter them from doing that. And, often people discount legal provisions that are not practically enforceable. I don't. People generally follow legal provisions, whether they're practically enforceable or not. If somebody has a confidentiality agreement, even if people rarely sue over NDAs, people usually respect their agreements, especially in the United States of America, where we follow rules. Other countries and some of the cross-border deals, a little less so, but here we generally follow rules.
Yeah, no, and that's important too. I mean, again, it might be something that the other side pushes back a little bit, but it's a simple way to just say to them, hey, I want to make sure you're serious, and they don't try and pull out of it last minute for no attachment to you. So it's a small fee probably on their end, but it's just something to think about and keep you a little more serious when you're dealing with the seller.
Yep, exactly. And we can skip over really the last few sections. It deals with termination. It deals with, the entire agreement. There's no other agreements outside of this agreement. The last point I'll make is on the final paragraph before the signature block. I'll make 2 points here. One is that we have, if you scroll down a little bit more, you'll see it says here, this is the expiration. So often LOIs contain this expiration language where, because we sign the LOI and send it over, if the seller countersigns the LOI and sends it back, it's a binding agreement, right? All those binding provisions are binding on us. Not that it affects the buyer very much, but we have this sort of expiration language. I usually give people about 72 hours. It's not legally impactful at all. It's really sort of emotionally It puts some pressure on the sellers emotionally. They see the agreement expires in 72 hours, and you would be shocked to hear how many times a seller's broker calls me up a few hours before expiration and says, "Hey, can we get another 24 hours on your LOI?" And I'm like, "It doesn't matter. If you send it back in 24 hours, we're going to sign it. So, take your time." But I say, "Oh, absolutely, we'll extend it for 24 hours."
Yeah, I like that. That's a good way to do it too. Right. Otherwise, they could just have all day to reshop your LOI to other people and try and drive the price up, and a little bit of urgency there in the document.
Exactly. And shopping an LOI is a problem. It's really hard to prevent against that. Expiration kind of helps a little bit. And the last point I'll make is always sign your LOIs as a buyer. It shows a level of commitment and dedication. And so I always encourage my buyers to sign their LOI before sending it to the seller. And then often, once it's sent off, sometimes I'll get a call from the seller's lawyer. Sometimes the seller's broker will call and we'll talk through it. And sometimes these LOIs get negotiated for a period of time before signing and moving forward.
Yeah, and we'll have to have you back on to go through the next stage of this whole process, which is the real show, the due diligence process for your kind of 60 to 90 days there. I noticed in that LOI, you did put 90 days in. So folks, thinking about that, if you want to put 60 or 90, that's probably standard. I mean, 60 is probably standard. So if someone pushes back, you can go down to 60, but 90 is probably more realistic in terms of a close, I would say. So, I think the 120 number you threw out is probably a little bit egregious in terms of what you're putting out there.
Yeah. And Dennis, if you had to pin me down, I would agree with you. 60 is probably the right number to put in an LOI.
Right.
Especially if you have automatic extensions, which I do in my LOI.
Yeah, I noticed that clause too as well. So yeah, I think 60 is probably the least offensive if you want to think about that. But
Great.
Thanks so much for taking the time. This has been really helpful. This is a question we get a ton about LOIs and the process. For those that want to contact Eli, they work at Albrecht Law. He's also very active on Twitter, has a ton of awesome articles on the legal side of these deals in the lower middle market. But I'll just kick it over to you to kind of finish up and just hear, what kind of deals you're targeting and when to get in contact with you. What's the best way to contact you for future clients or future business buyers that want to work with your firm?
Yeah. Thank you so much, Dennis. And thank you for the work you're doing in this community. I mean, putting out information for free to the community, I think is so critical. And I know you dedicate a lot of time and effort to it. And so I appreciate it. And I love your stuff. I love your content. So keep it up.
We'll do. We're figuring it out. We're getting there.
Yeah. No, you're doing amazing stuff. And there's a lot of people that are appreciative. So our clients, our typical clients are ones that really value sophisticated representation. I mean, we came from representing large private equity groups. And the reason I started Albrecht Law is because I believe that smaller buyers and sellers should be able to get the same sophisticated quality legal representation that like Platinum Equity or Carlisle or Apollo gets. So, we represented those clients and we're giving the same level of service to these smaller buyers and sellers at a reasonable price that's mostly contingent on closing. We've kind of constructed this engagement that's a lot like an investment banker, where we take a lot of our deal fees at closing if closing occurs, and we have very liberal deal forgiveness so that independent sponsors don't get stuck with massive deal fees. Usually if a deal dies, we forgive the rest of the deal fee and move on and hope to make it back on a future deal, just like the sponsor does. So we've developed a system that really works for smaller searchers, independent sponsors, and small PE. And those are our core clients, anywhere from $1 million in EBITDA to $10 million in EBITDA. We're looking to connect with clients that want long-term relationship. Albrecht Law is going to be around for at least the next 30 years if we all stay healthy. And we're looking for clients who have the same sort of long-term focus.
Oh, great. Thank you so much. And I'm sure we'll have you back on for some questions at some point. So this is the legal portion with Ellie. Next week, we'll have the tax portion with Josh on the Albrecht Law side. And they do a lot of great work in the lower middle market for those interested. So thanks so much for taking the time, and talk to you soon.